The fence ended at the creek. That was the thing James Rivera had always meant to fix. 3 sides of his 47 acres were marked clean, cedar posts, 5-strand wire, corners surveyed and staked in 2009, the year after he closed on the property and driven out here alone with a bottle of decent bourbon to stand in the middle of a field and understand what he'd done. The north line ran along the tree break. The east line followed the old county road. The west line cut through the hill pasture where he'd eventually put the goats. But the south line, the line that mattered now, the line that separated his land from the manicured entrance of Meadowbrook Estates, that line ended where the seasonal creek bent east, and from that bend to the property corner another 230 feet, there was nothing. No wire, no posts. He just grass that transitioned almost imperceptibly from his uncut pasture into their mowed common area. And if you didn't know where to look, you couldn't see the difference. He'd always meant to fix it. He hadn't fixed it. That was the original sin of this whole story. And James Rivera was honest enough with himself to name it. Not because the absence of a fence changed anything legally. It didn't. Not one syllable of the deed changed based on whether he'd strung wire, but because the absence of a fence gave people a story to tell themselves. It gave them the comfortable fiction that the boundary wasn't real because it wasn't visible, that unclaimed-looking land was available land, that if nobody was standing on it with a sign, it was open for interpretation. James had spent 22 years in military logistics, and he understood better than most how institutions run on narrative. Give people a gap in the fence and they'll build a whole mythology around why the gap was meant to be there. Meadowbrook Estates had been building that mythology for the better part of 14 months before James noticed. He noticed on a Saturday in October, the kind of morning that made farming feel like a reasonable life choice. Cool, clear, the light coming in low and golden across the south pasture. He'd come out to check on the drainage tile he'd laid along the creek bank, and he'd stopped walking because there were cars. Not one car. Not a neighbor who'd pulled off the road in a pinch. There were 11 vehicles parked in a loose row along the southern edge of his property, their bumpers facing his land, and their owners somewhere inside the Meadowbrook Common area where the HOA was running what a hand-lettered banner called the 3rd Annual Meadowbrook Market Day. Craft tables, a bluegrass duo. The smell of kettle corn drifting across the property line like it owned the place. James stood there for a moment with his hands in his jacket pockets and did the thing he'd trained himself to do in the army when a situation was worse than expected. He didn't react. He observed. He counted. He catalogued 11 vehicles. 2 of them had Meadowbrook Estates HOA parking permits hanging from their rearview mirrors. Small laminated cards, blue and gold, the HOA's colors, which meant this wasn't improvised. Somebody had issued permits for parking on land they didn't own. He walked back to the house and got his phone. He photographed all 11 vehicles. He photographed the permit cards visible through 2 windshields. He photographed the HOA banner in the background. He photographed his own deed, which he kept in a fireproof lockbox in the farmhouse office along with every other document that mattered. The title insurance policy, the survey plat, the closing statement from 2008, the county assessor's parcel record with his name printed in the field labeled owner, James Rivera. Parcel 14-0047-A. 47.3 acres. Purchased outright, no mortgage, no lien, no ambiguity. He called the county sheriff's non-emergency line. The deputy who answered was polite and unhelpful in the specific way of someone who has given the same answer many times and stopped feeling bad about it. Sounds like a civil matter, sir. James asked what that meant in practical terms, and the deputy explained that without evidence of criminal intent, unauthorized parking on private property was a civil dispute, not a criminal trespass matter, and that James would need to pursue it through civil channels. James asked what civil channels looked like. The deputy suggested he post signs. He posted signs. He drove to the farm supply store that afternoon and bought 6 metal sign stakes and 6 laminated signs that read, "Private property, no parking, violators will be towed." And he drove the stakes into the ground along the southern boundary at 40-foot intervals, and he felt, briefly, like a man who had solved a problem. The signs were gone by the following Thursday. Not vandalized, not knocked over. Gone. Stakes pulled cleanly from the ground, signs removed, the grass barely disturbed. James stood at the boundary line and looked at the 6 small holes in the earth where the stakes had been and felt something shift in his chest. Not anger, exactly. Something colder. The removal of those signs was not a spontaneous act. It was a decision. Someone had looked at his clearly worded boundary markers, considered them, and decided they were an inconvenience to be managed. He put the signs back up. He added a trail camera mounted on a fence post at the east end of the boundary, angled to cover the full southern line. He didn't tell anyone about the camera. The following Saturday was the second market day of the month. Meadowbrook ran them twice monthly, he'd since learned, April through November. And James was in the barn when he heard tires on the grass. He came out to find a white Range Rover parked 20 feet inside his property line, positioned with the confidence of a vehicle that had parked in the same spot before. The driver was already walking toward the Meadowbrook common area, a woman in her mid-40s, dark hair, wearing the kind of weekend casual clothes that cost more than they looked like they cost. She had a tote bag over one shoulder and a phone in her hand, and she was moving with the purposeful ease of someone who had somewhere to be. James called out to her. She stopped, turned, looked at him with an expression that was not quite surprise, more like mild inconvenience, the look of someone who has been interrupted by something they consider beneath their attention. He introduced himself. He told her she was parked on his property. He said it plainly, without heat, the way he'd learned to deliver bad news in the army. Clearly, directly, without apology for the content. She looked at him for a moment, then looked at her car, then looked back at him. Then she opened her phone and began to read. She read from what she identified as the Meadowbrook Estates HOA Community Standards and Bylaws, Section 11, Paragraph 3, which addressed parking provisions for community events and designated the Southern Common area boundary as an approved overflow parking zone. She read this with the careful emphasis of someone who has memorized a script and believes the script settles the matter. James waited until she finished. He asked her if she knew what a property deed was. She said she was Karen Ellis, a member of the Meadowbrook Estates HOA Board of Directors, and that the HOA managed this area. He told her the HOA did not manage this area. He told her this area was Parcel 14-0047-A, 47.3 acres, owned by James Rivera, and that the HOA's bylaws had no legal authority over private property outside the Meadowbrook Estates boundary. She looked at him the way people look at someone who is saying something technically true, but socially incorrect, with a kind of patient, slightly pitying tolerance. "We've been using this space for 3 years, she said. "It's never been a problem before." "It's a problem now," James said. She moved her car. She moved it without argument, which he noted because it meant she understood, on some level, that she had no ground to stand on. But she moved it slowly, and she looked back at him once before she drove away, and the look was not apologetic. It was the look of someone filing information away for later use. James went back inside and pulled up the trail camera footage from the previous 2 market days. He watched 43 minutes of video. He counted vehicles. He noted timestamps. He saw Karen Ellis's white Range Rover in the same spot on both previous Saturdays, arriving at 9:47 and 9:51 respectively, parking without hesitation. The driver never once looking at the boundary, never once behaving like someone who was uncertain about her right to be there. He opened a new folder on his laptop. He labeled it Meadowbrook. Documentation. He transferred the camera footage. He added the photographs from October. He added a scan of his deed. He added the parcel record from the county assessor's website, printed to PDF, his name in the owner field, should the boundary coordinates listed to 4 decimal places. Then he opened a legal pad and wrote, in the precise block letters of a man who had spent 2 decades writing logistics reports that had to be right because wrong reports cost lives. Incident log. Date. Time. Vehicle. Description. Witnesses. He wrote the first entry. He did not know yet how many entries there would be. He did not know yet about the certified letters, or the county complaint, or the emails that would eventually surface in discovery. He did not know yet about Maria Santos, or what a judge would say when presented with 47 dated photographs and a surveyor's note from 1987. He knew one thing with the certainty of a man who had read his own deed 40 times. The line was real. It had always been real. The fact that no one had respected it yet did not make it less real. It just meant the work was starting. The sheriff's deputy arrived 40 minutes after James called. Not because it was an emergency, the dispatcher had made that clear, but because James had asked politely, given the address twice, and waited. He was good at waiting. 16 years in military logistics had taught him that most problems weren't solved by urgency. They were solved by patience, documentation, and the willingness to outlast the people who believed their authority was self-evident. Deputy Carl Hutchins was a reasonable man. James could see that immediately. Mid-40s, a little soft around the middle, the kind of cop who'd chosen county work because he liked knowing his neighbors. He pulled up in his cruiser, stepped out. She looked at the white Range Rover sitting 20 feet inside the fence line, and nodded slowly the way men nod when they're calculating how much trouble something is going to be. James handed him the folder before he could speak. It was a habit from the army. Never make someone ask for what you already know they need. Inside, a copy of the deed, the county assessor's property map with the boundary line highlighted in yellow, and 3 photographs he'd taken that morning showing the Range Rover's position relative to the fence post and the survey marker embedded in the ground 6 inches away. Hutchins looked at the photographs. He looked at the Range Rover. He looked at the deed. "This your property?" he asked. "Yes," James said. "Since 2008, purchased outright. No liens, no disputes, no easements." Hutchins walked to the fence line, but looked at the survey marker, looked back at the car. He was doing the math. It wasn't complicated math. The car was on James's land. That was a fact as plain as the marker in the ground. Then his radio crackled. He stepped away to answer it, and James watched his posture change, the slight stiffening, the careful neutrality that comes when someone is receiving information that complicates a simple situation. When Hutchins came back, his expression had shifted from reasonable to apologetic. "Mr. Rivera," he said, "Mosh, I've just been informed that the Meadowbrook Estates HOA has a legal representative who's claiming there's a boundary dispute on file with the county planning department." James kept his voice level. There is no boundary dispute. The county assessor confirmed my property line last Tuesday. I have that confirmation in writing. He reached into the folder and produced it. Hutchins took it, read it, handed it back. "I understand that," Hutchins said. "And I'm not saying you're wrong, but when there's a claim of disputed boundary, even a claim without merit, it moves this into civil territory. I can't compel the vehicle to be moved. I can't cite the owner for trespass when there's an active civil claim about where the property line sits." "The claim was filed this morning," James said, "after I called your office." Hutchins looked at him steadily. "I know." There it was, not spoken plainly, but present in the space between them, the acknowledgement that the timing was not coincidental, that someone had made a phone call, that the machinery had been engaged specifically to neutralize the one tool James had reached for. He'd called the sheriff. So they'd called their lawyer, and their lawyer had filed a piece of paper, a baseless piece of paper, a paper that would be laughed out of any courtroom with a copy of his deed attached. But it didn't need to survive a courtroom. It only needed to survive this morning. It only needed to keep Deputy Hutchins' hands tied long enough for market day to end and Karen Ellis to drive her Range Rover home. James thanked the deputy. He meant it. Hutchins hadn't done anything wrong. He was operating inside a system that had just been gamed, and he knew it, and there was nothing either of them could do about it in that moment. James shook his hand, watched him drive away, and stood at his fence line looking at the white Range Rover for a long time. Then he went inside and made notes. He wrote down the time of the deputy's arrival, the time of the radio call, the deputy's name and badge number, the exact language Hutchins had used, active civil claim, boundary dispute, civil territory, and the timestamp on the planning department filing, which he pulled up online within the hour. Filed at 9:47 a.m. He had called the sheriff's non-emergency line at 9:12 a.m., 35 minutes. Someone had been ready. Someone had been waiting for him to make exactly that move. He photographed the Range Rover again at noon, at 2 o'clock, at 4:15, when Karen Ellis finally returned to it, smoothed her blazer, and drove away without looking toward the farmhouse once. James watched her go. He felt something that wasn't quite anger. Anger was too hot, too reactive, too likely to make you sloppy. What he felt was closer to clarity. The kind of clarity that comes when you understand exactly what you're dealing with and exactly what it will take to defeat it. He'd seen this before, not with HOAs, but with the kind of institutional confidence that mistakes its own procedures for reality. In the Army, it was the supply officer who insisted the requisition form superseded the field commander's direct order. It was the contractor who believed the contract language protected him from the consequences of what the contract language actually described. It was the certainty of people who had operated inside a system for so long that they'd confused the system's rules with the laws of physics. They weren't malicious, most of them. They were just absolutely, completely, dangerously sure. Meadowbrook Estates Homeowners Association had 400 homes, a lawyer on retainer, and 16 years of unchallenged authority. They had fined people for mailbox colors and won. They had sent cease and desist letters for unapproved landscaping and won. They had apparently decided that a farmer's unfenced southern border was available for community parking, filed a preemptive legal claim when challenged, and expected to win that too. They were sure because they had always been sure, and it had always worked. James opened his laptop and began building the file. He was methodical about it the way he'd been methodical about everything since he was 22 years old, and a senior NCO had told him that the difference between a soldier who survived and a soldier who didn't was usually paperwork. Not bravery, not strength, paperwork. The man who could prove what happened, when it happened, and who authorized it. That man walked out of the inquiry. The man who couldn't prove it didn't. He created a folder structure: deed and ownership, county records, incident log, photographic evidence, HOA communications, legal filings. He scanned every document he had and backed it up in 3 places: his hard drive, an external drive in the farmhouse safe, and a cloud account he created that morning with a password he wrote in his notebook in a cipher he'd been using since 1994. He was not a paranoid man. He was a prepared one. The deed was the foundation. He'd read it so many times in the past week that he could recite the legal description from memory: the metes and bounds, the survey markers, the recorded acreage. 47 acres, purchased outright on March 14th, 2008, from the estate of Harold Morrow, who had farmed it for 31 years before him. The title was clean. No liens, no encumbrances, no easements of any kind. He had paid a title company to confirm this at purchase, and he had the certification in a manila envelope in the safe alongside his discharge papers and his mother's death certificate. the documents that defined the shape of his life. The HOA had not existed when he bought the land. Meadowbrook Estates had broken ground in 2011, 3 years after his deed was recorded. Whatever authority they believed they possessed, it had been created after his ownership was established by people who had chosen to build adjacent to a working farm and had apparently decided, somewhere along the way, that the farm was a resource rather than a boundary. He found the planning department filing online and read it carefully. It was 2 pages. It claimed a Yeartraps's potential boundary discrepancy, based on Varalt community use patterns consistent with prescriptive easement. He looked up prescriptive easement on 3 separate legal websites to make sure he understood it correctly, and then he sat back and almost laughed. Prescriptive easement. The legal doctrine that allows someone to claim a right to use another person's property if they've used it openly, continuously, and without permission for a statutory period. In this state, 15 years. The HOA had been using his land for parking for, at most, 8 months. He had photographs from the first incident in April. He had a neighbor 2 miles down the road who'd mentioned seeing the market day crowds spilling over onto your south field for the first time last spring. 8 months. They needed 15 years, and they hadn't even had the courtesy to use it without permission. He'd told them to stop, in writing, twice. The filing was a bluff. It was a well-executed bluff, delivered at exactly the right moment to neutralize a sheriff's deputy on a Saturday morning. But it was still a bluff. And James Rivera had spent 16 years in military logistics, learning that the correct response to a bluff was not to fold and not to call loudly. The correct response was to document the bluff, understand its mechanism, and wait for the moment when the person who made it had forgotten they were bluffing. He closed his laptop at 9 o'clock that night. He'd eaten dinner standing at the kitchen counter, leftover rice and beans, a habit from field deployments he'd never quite broken. Outside, his south field was dark and quiet. The fence line was a shadow against the slightly lighter shadow of the sky. Tomorrow he would call the county assessor's office and ask for a formal written confirmation of his property boundary, specifically referencing the planning department filing by case number. He would ask them to note in writing that no legitimate boundary dispute existed. He would be polite. He would be precise. He would give them exactly what they needed to give him exactly what he needed. And then he would find a lawyer, not because he was angry, or not because his pride demanded satisfaction, but because the people on the other side of his fence line had made a calculated decision that he would not fight, that the cost and complexity of challenging institutional authority would be enough to make him absorb the loss and move on. They had looked at a farmer standing alone at a fence line and seen someone who could be managed. They had the wrong man's fence line. The county recorder's office smelled like old paper and floor wax. James had been there twice before, once when he bought the property, once when he refinanced in 2014. Both times he'd been in and out in under 20 minutes. This time he pulled a chair to the microfiche terminal at 9:03 in the morning and didn't look up until the fluorescent lights above him flickered on their noon cycle. He wasn't looking for anything specific. That was the discipline Maria Santos had drilled into him during their second phone call, before he'd even formally retained her. Don't go in looking for what you want to find. Go in looking for everything. The difference between those two approaches was the difference between a man building a case and a man building a story. James had spent 22 years in military logistics. He understood the difference. A story collapsed under cross-examination. A case didn't. What he found in the first 2 hours was confirmatory, but not surprising. The deed was clean. His name, the parcel number, the acreage, 47.3 acres, not 47. The 0.3 mattering the way decimal points always matter when someone is trying to shave off the edges of what belongs to you. The chain of title went back to 1962 without interruption, without dispute, without so much as a footnote. He photographed every page anyway. Then he found the survey. It was filed in 1987, 21 years before James bought the property, 7 years before the first Meadowbrook Estates home broke ground. The original landowner at the time, a man named Gerald Pruitt, had commissioned it independently. Not as part of a sale, not as part of a subdivision application, but as a standalone boundary clarification. The surveyor's name was stamped at the bottom of each page. R.W. Callaway, Licensed Land Surveyor, State Certificate 4471. The survey itself was meticulous. Every corner marker noted. Every bearing and distance recorded to the hundredth of a foot. And on the final page, in the margin, in handwriting that had faded to the color of weak tea but remained entirely legible, was a note. James read it twice before he photographed it. Then he read it a third time. Landowner specifically requested clear boundary markers to prevent future encroachment. Southern boundary staked at 4 points per owner instruction. Owner states adjacent land to south is undeveloped and expresses concern ARSWAT's future development pressure on boundary. Markers placed accordingly. RWC, March 14, 1987. Gerald Pruitt had seen it coming. 37 years ago, a man standing on the same southern edge of the same land had looked toward what was then empty field and understood, with the particular clarity of someone who had watched development swallow farmland his entire life, that the boundary would one day be contested. He had paid a surveyor to stake it 4 times over. He had asked that the concern be written down. James sat with that for a moment. The fluorescent lights hummed. Somewhere behind him, a county employee rolled a cart of file boxes across linoleum. He thought about Gerald Pruitt, who he had never met, who had sold the property to a couple named Hendricks in 1994, who had probably never imagined that his careful, worried marginal note would one day become evidence in a lawsuit. He thought about the specific loneliness of being right about something that won't matter for decades. He photographed the note 3 times from different angles. He requested a certified copy from the clerk at the front desk, paid the $11 fee, and kept the receipt. He was back in his truck by 2:15. Maria Santos was in court when he called. So he left a voicemail that was, by his own later admission, considerably less composed than he would have preferred. He described the survey note in full. He described the 4 staked corners. He described R.W. Callaway's handwriting and the date and the certificate number. He said, at the end, "I think Gerald Pruitt just testified for us." And then he hung up and drove home through the flat afternoon light, with the certified copy on the passenger seat beside him, like a passenger. Maria called back at 6:47 that evening. "Tell me about the note again," she said, slowly. He told her. He heard her writing. "The surveyor's still licensed?" she asked. James hadn't checked. He checked while she waited, pulling up the state licensing board on his laptop. R.W. Callaway. Retired, but license in good standing, no disciplinary history. No address listed in the county, 12 miles away. He's local," James said. "Of course he is," Maria said, and he could hear something shift in her voice. Not excitement exactly, but the particular focus of someone who has just watched a door open that they expected to be locked. "I want you to understand what you found today. The HOA's entire prescriptive easement argument depends on demonstrating that the boundary was ambiguous, that your predecessors in title failed to adequately assert their rights. Callaway's note destroys that. It establishes that the boundary was not only clearly marked, but specifically reinforced against encroachment by the owner's explicit instruction 37 years ago. There is no ambiguity. There has never been ambiguity. They just decided to ignore what was there." James said, "Can we get Callaway to testify?" "I'm going to call him tomorrow morning," Maria said. "But honestly, the note may be enough. A surveyor's field notation is a professional record. It's contemporaneous. It's signed and dated and certified. Their lawyer is going to look at this and start having a very uncomfortable conversation with his clients. She paused. You said you were pulling all the HOA documents too. We're still working through them, James said. Their bylaws, their meeting minutes, everything they've filed publicly, IQ. Keep going. She said. I have a feeling the survey isn't the only thing they didn't read carefully. She was right. He found it 3 days later at his kitchen table at 11 o'clock at night, working through the Meadowbrook Estates governing documents that the HOA had filed with the county as part of their original 1994 incorporation. The documents were 94 pages. He had been reading them the way he had once read supply manifests in the Army. Not for the broad strokes, but for the specific language, the subordinate clauses, the definitions buried in subsections that nobody reads because everybody assumes they already know what the document says. Section 4.2 was on page 31. Jurisdiction and authority. The association's authority to enforce these covenants, conditions, and restrictions applies exclusively to properties within the recorded boundaries of Meadowbrook Estates, as established by the plat of record, filed date. The association has no authority over properties outside the Meadowbrook Estates boundary, and nothing in these governing documents shall be construed to grant the association any rights, easements, or interests in properties not included within said boundary. He read it 4 times. He read it the way you read something when you're waiting for it to mean something different than it means, when you're sure you must be misunderstanding, because what it actually says is too clean, too complete, too perfectly suited to the situation at hand to be real. It was real. The HOA had filed a complaint with the county planning department claiming authority over his land. Karen Ellis had stood on his property and read him the HOA bylaws as though they governed what he could do with his own acreage. Diane Foster had signed a certified letter asserting that James was obstructing community access. Access to land the HOA's own founding document explicitly acknowledged it had no authority over. They hadn't just ignored his deed. They hadn't just ignored the survey. They had ignored their own rules. James photographed the page. He highlighted section 4.2 in yellow. He sent the photograph to Maria Santos at 11:23 p.m. with a single line of text, page 31 of their own bylaws. She responded 4 minutes later, which told him she had been awake, which told him she'd been thinking about this case the way he had been thinking about it. Not as a job, but as a problem that deserved to be solved correctly. Her response was 3 words. Oh, they're done. He set his phone down on the kitchen table. Outside, the farm was dark and quiet, the southern boundary invisible in the November night, but present the way it had always been present, staked at 4 points by a careful man in 1987, recorded in the county's files, written into the deed, written into the HOA's own governing documents, written into every piece of paper that had ever touched this land. The boundary had never moved. The boundary had never been ambiguous. The boundary had been there the entire time, waiting with the patience of something that doesn't need to argue, because it simply is. James turned off the kitchen light and went to bed. The county records office smelled like the inside of a filing cabinet. That particular combination of old paper, fluorescent light, and institutional indifference that James had come to associate with every government building he'd ever waited inside. He'd spent enough time in them during his army years. Supply depots, logistics centers, contracting offices, where the air itself seemed to slow down, where urgency went to die. He knew how to move through these spaces. You didn't push, you didn't demand. You asked the right questions in the right order, and you waited, and eventually the system gave you what it had been holding all along. He'd been here 3 times in the past 2 weeks. The first visit had confirmed what he already knew. His name on the deed, the parcel number, the recorded purchase date of March 14, 2008. Clean, unambiguous, the kind of ownership that should have ended the conversation before it started. But the HOA's lawyer had used the word prescriptive easement in that certified letter. May and James had learned long ago that a word deployed by a lawyer was never accidental. It was a weapon. Small caliber, maybe, but pointed. Prescriptive easement required years of open, continuous, hostile use of another person's land. It was the legal doctrine that said, if you trespass long enough and nobody stops you, the trespass becomes a right. It was, in James's considered opinion, one of the more philosophically offensive concepts in American property law. But it existed. Courts had upheld it, and the HOA's lawyer knew that even a baseless claim, filed with enough paperwork behind it, could cost a man more to fight than to surrender. So James had come back to the records office. Not to confirm what he owned. He already knew that. He came to find out what the land remembered. But the clerk, a woman named Patrice who wore reading glasses on a beaded chain and had the energy of someone who had personally outlasted 4 county commissioners, had pulled the original survey documents from 1987 without being asked twice. James had learned to bring coffee, not as a bribe, as a signal. It said, "I'm not in a hurry, I respect your time, and I'm going to be thorough." Patrice had warmed to him on the second visit. By the third, she'd pulled a box he hadn't known to ask for. Her original field notes, she said, setting it on the counter with the particular care of someone handling something irreplaceable. Surveyor's working documents. They don't always get digitized. Most people don't know to ask. James had put on the cotton gloves she offered and opened the box, when the survey had been commissioned in 1987 by the previous owner of the property, a man named Harold Cutler, who had farmed the land for 30 years before selling it in stages. The formal survey documents were what James expected: precise measurements, boundary markers, legal descriptions in the dense shorthand of professional land work. He read through them carefully, the way he'd once read logistics manifests, looking not for what was there, but for what didn't match. And then, on the 4th page of the field notes, in the cramped handwriting of a man who had stood on this land 37 years ago with a transit and a rod, and the particular patience of someone whose job was to make the invisible permanent, he found it. A single handwritten annotation in the margin, separate from the formal notation. Not part of the legal description. A note. Personal, almost conversational in its directness. Landowner specifically requested clear boundary markers to prevent future encroachment. Stakes placed at 50-foot intervals along southern boundary per owner instruction. Landowner expressed concern, replanned residential development to the south. James read it twice. Then he set the page down and looked at the fluorescent light above him for a moment, the way a man does when something slots into place that he'd been waiting to feel slot into place. Harold Cutler had seen it coming. 37 years ago, before Meadowbrook Estates was anything more than a developer's rendering on a conference room wall, the man who owned this land had looked south and understood exactly what was going to happen. He'd paid a surveyor to drive stakes into the ground every 50 feet along that southern boundary. He'd said, in writing, through a professional intermediary, "This line is real, this line is intentional, and I want it known that I knew it was here." The HOA's prescriptive easement argument rested on a specific legal requirement, that the use of the land had to be hostile to the owner's knowledge, that the owner, in some meaningful sense, hadn't objected, that the trespass had gone unchallenged long enough to ripen into something resembling a right. Harold Cutler had objected before the trespass began. James photographed every page of the field notes with his phone, then asked Patrice for certified copies of the complete file. She processed the request without comment, though she did look at him over the top of her reading glasses, with the expression of someone who understood, without being told, that something had just shifted. He sat in his truck in the parking lot for a few minutes before driving home. Not because he needed to collect himself, because he wanted to think clearly about what he was holding. The HOA had sent their certified letter 11 days ago. Their lawyer's argument, the prescriptive easement claim, was the kind of legal maneuver designed to create uncertainty where none existed, to make James doubt what he knew, to make the cost of fighting feel higher than the cost of giving up. It was institutional judo. Use the weight of the system against the person the system was supposed to protect. He'd seen it before, in contracting disputes during his army years, when a vendor with a lawyer on retainer would bury a legitimate complaint under procedural filings, until the complainant simply ran out of time and money and will. The HOA had done this before. He was certain of it. Not to him specifically. He'd only been in their crosshairs for a few months. But this pattern, this particular combination of confident overreach and legal threat, didn't emerge from nowhere. Organizations didn't develop this kind of institutional muscle without having used it. What they hadn't accounted for was Harold Cutler's surveyor sitting in a field in 1987, writing a margin note that nobody had thought to look for. The prescriptive easement argument required the HOA to prove that the use of his land had been continuous, open, and, critically, without the landowner's objection. What the survey note didn't just document the boundary, it documented intent. It documented a landowner who had specifically anticipated encroachment from the south and had taken formal, recorded, professional steps to prevent it. The note was dated. It was signed. It was part of the official county record. It didn't just undermine the HOA's argument. It inverted it. Every stake Harold Cutler had asked that surveyor to drive into the southern boundary was a documented act of objection. 37 years of objection, recorded before Meadowbrook Estates, had poured a single foundation. James drove home on the county road that ran along his eastern fence line, the way he always did when he needed to see the land from the outside. The fields were going brown at the edges now, the way they did in October, because the cover crop he'd planted in August lying low and dense across the south pasture. The southern boundary was visible from the road, the fence line he'd repaired in August, the posts he'd set himself, the wire he'd stretched tight enough to hold. Somewhere beneath the grass along that line, Harold Cutler's survey stakes were still in the ground, 50 feet apart, driven there by a man who understood that a line you couldn't see was still a line, and that the only way to protect it was to make sure someone had written it down. James had the certified copies on the seat beside him. He had the photographs on his phone. He had the deed, the county assessor's confirmation, 47 dated photographs of HOA vehicles parked on his land, and now this, a 37-year-old margin note from a surveyor who had never met him, but had, in some precise and practical way, been working on his behalf since before James Rivera had ever heard of Meadowbrook Estates. He pulled into his driveway and sat for a moment with the engine off. He thought about what Maria Santos had said when he'd first called her office, that she'd need to see the documentation before she could assess the case, that property disputes were complicated, that the HOA's prescriptive easement claim was aggressive but not frivolous. He picked up his phone and called her. When she answered, he said, "I need to send you something. I think you're going to want to see it tonight." The county records office smelled like the inside of a filing cabinet, that particular combination of old paper, fluorescent light, and institutional indifference that James had come to associate with bureaucratic waiting. He had been here 3 times in the past 2 weeks. The clerk at the front desk, a heavy-set man named Gerald, who wore the same green cardigan every day, had stopped asking James for his ID. He just nodded now, the way you nod at someone you recognize from church but don't particularly want to talk to. James took his usual seat at the microfiche terminal in the back corner and opened his notebook to a fresh page. He had come looking for one thing and found something else entirely. That was how it always worked in his experience. In logistics, in farming, in the slow grinding machinery of legal conflict. You planned for the objective in front of you, and the terrain revealed a different objective, one that mattered more. He had learned that in Kuwait in 1991, standing in a supply depot watching a manifest that didn't match the trucks in front of him. The discrepancy was the story. The discrepancy was always the story. He had come to the records office looking for the original plat map of the Meadowbrook Estates development, something that might show the precise boundary between their planned community and his land, something he could use to counter the HOA's laughable prescriptive easement claim. Maria Santos had suggested it. Find the original development filing, she'd said over the phone, her voice carrying the particular efficiency of someone who had learned not to waste words on cases she believed in. If they drew the boundary themselves, they can't claim they didn't know where it was. He found the Meadowbrook plat map in 20 minutes. It was exactly what he expected. A clean 1994 survey showing the development boundary and his land sitting outside it with the same clarity as a fence post in open ground. He photographed every page with his phone, methodical and unhurried, the way he photographed everything now. Then Gerald, in a moment of either professional courtesy or simple boredom, mentioned that there was an older survey in the same property file. Goes back to 87, Gerald said, setting a manila folder on the table, with the careful disinterest of a man who had long since stopped caring what was in the folders he carried. Came in with the original deed transfer. Hasn't been pulled in probably 15 years. James opened it. The 1987 survey was hand-drafted, the kind of precise technical drawing that predated CAD software and carried in its careful ink lines the personality of the person who made it. The surveyor's name was printed in the lower right corner. Harold Birch, licensed land surveyor, county certification number 4471. The boundary lines were exact and unambiguous. His 47 acres sat on that paper the way they sat on the earth, complete, defined, belonging to themselves. But it was the handwritten note in the margin that stopped him. Not a stamp, not a form notation. A note, written in the careful cursive of a man who had wanted to be precise about something that mattered to him. James leaned forward until his nose was 8 inches from the paper. Landowner specifically requested clear boundary markers to prevent future encroachment. SE corner post set at landowner's direction. NE and northwest corners confirmed with adjacent property owners present. Landowner expressed concern re. Future development pressure on southern border. All markers set to surveyor's higher standard per landowner's request. James sat back in his chair. He read it again. The landowner referenced was not James. He had purchased the property in 2008. The landowner in 1987 was a man named Earl Purcell, a retired railroad engineer who had farmed the land for 30 years before selling it. James had met Earl exactly once, at the closing, a brief handshake in a lawyer's office. Earl had been 79 years old, moving to be near his daughter in Arizona, and he had said only one thing to James that James had remembered. Kai said that land knows what it is. Don't let anybody tell it different. James had thought it was the kind of thing old men said, poetic and vague and not particularly useful. He understood it now. Earl Purcell had seen it coming. 30 years before Karen Ellis parked her white Range Rover on his southern field. Before Diane Foster sent certified letters about community access. Before the HOA's lawyer invented a prescriptive easement out of institutional wishful thinking. Earl Purcell had stood at his southern border with a surveyor and said, "Mark this clearly, because someone is going to try to take it." James photographed the note from 4 angles. He photographed the entire survey document, page by page. He photographed the certification number, the date stamp, the file number in the county's indexing system. Then he sat for a moment with his hands flat on the table and let the weight of it settle. This was not just documentation. This was intent. This was a landowner, on record, in a legally filed survey, specifically anticipating encroachment on the southern border and specifically requesting measures to prevent it. It didn't just prove the boundary existed. It proved the boundary had been deliberately and formally established against exactly the kind of pressure the HOA was now applying. He called Maria Santos from the parking lot. She listened without interrupting, which was her habit when something was important. When he finished reading her the marginal note, there was a pause of approximately 4 seconds. "So where are you right now?" she asked. "Quo's parking lot of the county records office." "Go back inside and request a certified copy of that entire survey file. Pay whatever it costs. Get the certification stamp on every page." "Already planned on it?" James saying. Another pause, shorter. This is the kind of document that ends cases before they go to trial. Their prescriptive easement argument requires them to prove the use was open, continuous, and, critically, that the landowner had no objection and took no steps to establish a boundary. You now have a 1987 survey, filed in county records, showing the landowner specifically and formally established that boundary and specifically anticipated encroachment. Their entire legal theory just collapsed. He went back inside. Gerald made the certified copies without comment, stamped each page with the county seal, and charged James $14. James paid in cash and put the envelope in the interior pocket of his jacket, against his chest, the way you carry something you don't want to lose. He drove home through the county roads he knew by memory, past the fields that were beginning to show the first pale green suggestion of the season's second planting, past the grain elevator that had been there since 1962, even past the intersection where the Suburban Development's brick entrance sign, "Welcome to Meadowbrook Estates, a community of excellence," faced the open farmland with the cheerful obliviousness of something that had never considered what was there before it arrived. He pulled through his own gate, the one with the private property sign that someone had removed twice and that he had replaced twice with a heavier post and a longer bolt, and parked in front of the barn. He sat in the truck for a moment. The HOA had filed their complaint with the county planning department 11 days ago. The complaint alleged he was operating an unlicensed commercial farm in violation of residential zoning, a claim so factually wrong that it had initially seemed too absurd to take seriously, until Maria explained that absurdity was sometimes the point. "Geet, they're not trying to win that complaint," she had said. "They're trying to create a paper record of dispute. They want a disputed boundary notation in the county system. They want your property to look complicated. Complicated properties lose value. Complicated property owners settle." The property value drop had already happened. $40,000 gone from the assessor's estimate, tied directly to the dispute notation the HOA's complaint had generated. His insurance company had called twice. His neighbor to the north, a quiet man named Pete Schaefer, who ran a small cattle operation, had mentioned carefully that he'd heard there was some kind of issue with the southern parcel. The HOA's strategy was working exactly as designed, not through legal victory, but through the slow accumulation of institutional noise, the kind that made a man feel like his certainty about his own land was somehow in question. But the deed was not in question. The deed had never been in question. James Rivera had purchased 47.3 acres of Harmon County farmland on March 14, 2008, in a clean cash transaction with no liens, no encumbrances, no easements of any kind recorded against the property. The title search had been thorough. The deed was filed in the county recorder's office the same day. His name was on it the way his name was on his military discharge papers. Permanent, documented, not subject to revision by people who found it inconvenient. The HOA's lawyer had used the phrase prescriptive easement as if it were a weapon. It was, in the right circumstances. Years of open, continuous, uncontested use could, under certain legal conditions, create a right of access that survived even clear ownership. It was the kind of legal doctrine that sounded reasonable in a law school classroom and became a tool of institutional aggression in the hands of an organization that had decided its convenience outweighed someone else's property rights. But prescriptive easement required uncontested use. It required a landowner who had not objected, had not established boundaries, had not created a record of opposition. Earl Purcell had created that record in 1987. James Rivera had extended it with every photograph, every dated log entry, every certified letter, every replaced fence post. The HOA had not found an uncontested border. They had found the most documented border in Harmon County. He got out of the truck, walked to the barn, and pinned the certified survey to the corkboard above his desk, the one where he kept every document in this case, organized by date and category, the way he had once organized supply manifests in a forward operating base where disorganization cost lives. He stepped back and looked at the board. The 1987 survey sat at the top, Harold Birch's careful cursive visible even from a distance. Below it, the deed, the photographs, the HOA's own bylaws, Section 4.2, highlighted in yellow, the certified letters, the planning department complaint, the insurance company correspondence, the assessor's revised valuation. He looked at all of it for a long time. Then he picked up his phone and called Maria Santos again. "I want to file," he said. The conference room on the 14th floor of Hargrove and Pell smelled like recycled air and old ambition. Maria Santos had reserved it for the afternoon, and by 2 o'clock she had covered the long mahogany table with printed emails, sorted into color-coded stacks, yellow for awareness, red for intent, blue for coordination. James Rivera sat across from her and watched her work the way he used to watch his logistics officers prepare a theater briefing. The same economy of motion, the same quiet that meant something serious was about to be said out loud. They knew, Maria said. She didn't look up. She was still sorting. James had suspected it for months. Suspicion is one thing. Watching a lawyer lay the proof across a table in neat, color-coded rows is something else entirely. It has weight. It has corners. But she slid the first email across to him. It was dated 14 months ago, 8 months before James had posted his first no parking sign, 10 months before Karen Ellis had stood on his southern pasture and read HOA bylaws at him like scripture. The sender was Karen Ellis. The recipient was Diane Foster, HOA president. The subject line read, "Market Day Overflow, Permanent Solution." James read it slowly, the way Maria had taught him to read documents. Not for the emotion, for the facts. "Diane, I've been looking at the southern lot situation. The land technically belongs to the farmer on the other side of the line, but the boundary isn't marked and nobody's going to check the deed. We've been using it informally for 2 years already. If we just keep using it, we establish the pattern. But legal said something about prescriptive easement being a possibility down the road. I think we just keep going and see what happens. Nobody's complained yet." James set the email down. He pressed his palms flat on the table. "Nobody's complained yet, Tom," he said. "Thayer, keep reading," Maria said. The second email was Diane Foster's reply, sent 4 minutes later. 4 minutes. She hadn't deliberated. She hadn't consulted anyone. She had read Karen's proposal and answered it in the time it takes to pour a cup of coffee. "Agreed. We need the parking. Market Day is our biggest community event and we're turning people away. Make it work. Don't put anything in the official minutes about the boundary question. Just list it as overflow parking management. We'll deal with the deed issue if it ever becomes an issue." If it ever becomes an issue. But James had been a logistics officer for 22 years. He had planned supply chains across 3 continents. He understood at a cellular level what it meant to make a calculated decision about acceptable risk. He recognized the architecture of this email immediately, not malice, not stupidity, but something he found almost harder to stomach. It was a risk assessment. They had looked at his land, looked at his deed, looked at him, and decided he was an acceptable risk, a variable they could absorb, a problem that probably wouldn't materialize. He had materialized. Maria was watching him read. She had the particular stillness of someone who has delivered this kind of news before and knows to let it land without narration. "Sure, how many?" James asked. "Irrelevant emails? 47. The ones that matter most? Until about 12. She tapped the red stack. "These are the ones that establish knowing trespass. They can't claim innocent mistake. They can't claim good faith belief that the land was common property. They discuss the deed. They discuss the boundary. They made a deliberate decision to proceed anyway and to keep it out of the official record." James thought about the county sheriff's deputy who had stood at the edge of his pasture 14 months ago and told him this was a civil matter. He thought about the letter from the HOA's attorney claiming prescriptive easement. The language designed to sound authoritative, to sound inevitable, to make James feel like the land beneath his feet was already slipping away from him. He thought about the $40,000 drop in his assessed property value, the insurance call, and the violation notice from the county planning department. All of it. Every piece of institutional pressure they had brought to bear on him. And underneath all of it, this: we need the parking. Make it work. "There's more," Maria said. She pulled a single sheet from the blue stack and handed it to him. This one's from 3 weeks after you posted your no parking signs." The email was from Karen Ellis to the full HOA board. James read the subject line: Neighbor Issue, Strategy. "Board, as you know, the farmer on the south side has posted signs claiming the overflow area is private property. I've spoken with him directly and he's being difficult. I want to be clear that our legal position on this is solid. We've been using the space for over 2 years, and the prescriptive easement argument gives us cover. I've asked Tom at Hargrove to draft a letter. In the meantime, I'd suggest we continue using the parking area as normal. If we stop using it, we undermine our own easement claim. We need to maintain continuous use. Also, someone keeps removing his signs. I don't know who that is and I'm not asking." James read the last 2 sentences twice. "I don't know who that is, and I'm not asking." She knew," he said. "She knew," Maria confirmed. She didn't want it in writing, but she knew. And by putting it in writing that she didn't want to know, she created a record of the decision not to investigate, which is almost worse. James thought about the morning he had driven out to his southern fence line and found his signs gone. But he had stood there in the early light with the dew still on the grass and felt something he hadn't felt since his last deployment, the particular helplessness of being in the right and having no mechanism to enforce it. He had gone back to the house and printed new signs, laminated them this time, zip-tied them to the fence posts. Those had lasted 4 days. He had documented every removal, dates, times, photographs. He had done it because he was a logistics officer, and documentation was reflex. He had done it not knowing that 14 months later, he would be sitting in a conference room on the 14th floor of a law firm, watching a lawyer sort those photographs into evidence stacks. Should the prescriptive easement argument, sure, James said. Be their lawyer sent that letter like it was settled law. "It's not settled anything," Maria said. She sat down across from him for the first time since he'd arrived. "Prescriptive easement requires open, notorious, continuous, hostile and adverse use for a statutory period. In this state, that's 15 years. They've been using your land for, at most, 2.5 years. Their own emails establish the timeline. Their own emails establish that they knew it was your land. Hostile and adverse use requires the user to be acting against the owner's interest without permission. which they were. But you also have to meet the time requirement. They don't come close. Their lawyer sent that letter hoping you didn't know the law. Or hoping I didn't have a lawyer, James said. That too. He looked at the red stack again. 47 emails. 14 months of institutional certainty, laid bare in corporate shorthand, and reply-all threads. He thought about Diane Foster, who had spent 30 years in HR and knew exactly how to manage a situation, how to keep the uncomfortable decisions out of the official minutes, how to create plausible distance between the board's actions and the board's knowledge. He thought about how well that strategy worked against people who didn't have the documentation, the legal knowledge, or the will to fight back. He had all three. He'd had them from the beginning. They had simply never believed he would use them. Show 'em the defamation piece, James said. The board meeting minutes. Karen calling my property an eyesore on the record. Maria nodded. Public record statement, made in her capacity as a board member, about a neighboring property owner, is not strong on its own. Defamation requires falsity and damages. An eyesore is arguably opinion. But combined with the false complaint to the county planning department, the unlicensed commercial farm allegation, that's different. That complaint was factually false. They filed it knowing it was false, and it caused measurable harm. She tapped a folder at the end of the table. Your property assessment dropped $40,000. We have the assessor's notation, disputed boundary. That notation exists because of their complaint. That's a number. Numbers matter in court. James had spent 16 months watching his land treated as a resource to be managed by people who didn't own it. He had watched the HOA's institutional machinery grind forward with the serene confidence of an organization that had never been seriously challenged. He had watched Karen Ellis stand on his pasture and read bylaws at him. He had watched the sheriff's deputy shrug. He had watched a lawyer's letter arrive in his mailbox, claiming rights to his land that had no legal basis and were designed entirely to make him feel like fighting back was futile. What the HOA had never understood, what their emails made devastatingly clear they had never even considered, was that James Rivera had purchased 47 acres of farmland in 2008 with a cashier's check and a deed recorded in the county register's office. And he had read that deed, and he had kept that deed, and he had known every word of it for 16 years. The land was his, not approximately, not arguably, not pending a legal determination. His. The deed was not a document that could be outmaneuvered by 2 years of unauthorized parking and a letter from a retained attorney. It was the foundation. Everything else was built on top of it, and everything the HOA had built was built on air. What happens now? James asked. Maria squared the red stack against the table edge. Now I send their attorney a supplemental evidence disclosure. I include the emails, all 47. I include a formal demand for damages, the $40,000 in assessed value loss, legal fees, and a permanent injunction against any HOA use of or claim to your southern parcel. She paused. I also include a note that we are prepared to share this discovery with the local press if the matter is not resolved within 30 days. Is that standard? It's honest, Maria said. The emails are going to become public record the moment this goes to trial. I'm simply giving them the opportunity to understand that before it happens. She looked at him steadily. They made a calculated risk assessment about you, James. They decided you were the kind of problem that would go away. I want them to understand, in writing, that they were wrong. James looked at the table, at the yellow stack and the red stack and the blue stack, at 47 emails that had been written in the certainty that no one would ever read them in a conference room on the 14th floor of a law firm. Send it, he said. The story broke on a Tuesday, not because anyone planned it that way, Not because Maria had called a reporter or James had posted something online. It broke because a woman named Terry Okafor, who lived in Unit 214 of Meadowbrook Estates and had been fined $300 for planting yellow marigolds instead of the HOA-approved white impatiens, had been following the court filings on the county clerk's public portal. She'd been following them the way a person follows a fire they've been waiting years to see reach the right building. Terry posted a screenshot of the trespass complaint on a local Facebook group called Millhaven County Neighbors. She wrote 4 words above it. They did it again. By Wednesday morning, the post had 400 shares. By Thursday, a reporter from the Millhaven Gazette named Paul Decker had called James's cell phone twice and left a message with Maria's office once. By Friday, Paul Decker was standing at James's fence line with a photographer, looking out across 47 acres of winter brown pasture, and James was deciding whether to let him in. Maria had advised him carefully. You don't need the press," she'd said. "The case is already won on the merits, but if you want the lesson to stick, if you want Meadowbrook to think twice before they do this to the next person, then yes, let him in. Show him the deed. Show him the survey. Let the property speak for itself." James opened the gate. He walked Paul Decker to the southern boundary first. He showed him the fence posts he'd installed in September, each one set precisely on the survey line, but each one photographed before and after installation with a GPS timestamp. He showed him the ground where Karen Ellis's Range Rover had sat, the tire impressions still faintly visible in the soft earth near the drainage swale, preserved by the cold and by James's deliberate decision not to disturb them. He showed him the private property, no parking signs, the originals, still in his barn, still bearing the scuff marks from where someone had tried to pull them off their post. Then he brought Paul Decker inside and showed him the deed. He'd had it framed, not out of vanity, out of precision. He'd had it framed behind UV protective glass in a simple black frame, and hung it on the wall of his farm office between the USDA soil maps and the crop rotation calendar. The deed was dated March 14, 2008, but it named James Michael Rivera as sole owner of record. It described the property in meets and bounds language that was unambiguous, uncontested, and had been unambiguous and uncontested for 16 years. The county assessor's office had confirmed it. The title company had confirmed it. The judge reviewing the trespass complaint had confirmed it in his preliminary findings with the phrase, "Winnemazan ownership not in dispute." Paul Decker photographed the deed on the wall. He photographed the survey with the handwritten note. He photographed the fence line and the tire impressions and the signs in the barn. He asked James how long this had been going on. "Months before I noticed," James said, "probably longer before that." And the HOA's position was that they had the right to use the land? Their position, James said, was that nobody would check. That sentence ran as the pull quote in Saturday's edition. It ran above the fold. The Gazette piece was measured. Paul Decker was a careful writer, but the facts were stark enough that measurement almost didn't matter. Private landowner. Clear deed. HOA board member caught in internal emails acknowledging the land wasn't theirs. The phrase, "It's technically not ours, but nobody's going to check the deed," appeared in the article in full, attributed to Hans' internal HOA communications obtained through the discovery process. Maria had cleared the disclosure. The emails were already part of the public court record. There was nothing the HOA's attorney could do about it except watch. The comments section of the online article was, within 6 hours, a confession booth, and residents of Meadowbrook Estates began posting their own stories. The Marigold fine. A man named Gerald Hutchins, who'd been threatened with a lien for installing a wheelchair ramp without board approval. a ramp his wife needed after her hip replacement. A family who'd received a violation notice for a children's basketball hoop that was, by their measurement, 4 inches too close to the street. A woman who'd been told her wind chimes were a noise nuisance under a bylaw that, when she looked it up, didn't actually exist in the current governing documents. None of these stories were James's story. None of them involved trespass or excavators or a Range Rover buried in dirt. But they were the same story in the way that all stories about institutional certainty are the same story. An organization that had never been seriously challenged had confused its own authority with law and had kept confusing it until someone with a deed and a lawyer and 16 years of patience said enough. By Sunday, the Millhaven Gazette piece had been picked up by 2 regional outlets and 1 national property rights blog, with a readership of 80,000. The headline the blog used was blunter than Decker's. HOA admits in writing. They knew the land wasn't theirs. Park there anyway. James didn't read the comments. He'd learned that from his years in logistics. You manage the information you can act on and you ignore the noise. But Maria read them. And Maria called him Sunday evening with something in her voice he hadn't heard before. Not excitement exactly, more like the particular satisfaction of a person who has been right about something for a long time and has just watched the world catch up. Diane Foster resigned this morning, she said. James was quiet for a moment. Outside his kitchen window, the pasture was dark and the fence line was a thin pale thread in the moonlight. From the board, he asked. From the board, effective immediately. She sent a letter to the residents. It's already been posted online. She says she's stepping down to allow new leadership to guide Meadowbrook through this challenging period. She doesn't mention the lawsuit. She doesn't mention the emails. She doesn't mention your name. Does Karen Ellis resign? Not yet, Maria said. But 3 board members have called the HOA's attorney, asking whether their personal assets are exposed. The answer, by the way, is complicated, which means the answer is yes. James thought about the moment Karen Ellis had stood on his land and read him the HOA bylaws, the absolute confidence of it, the institutional armor of it, the belief that the rules she carried in her phone superseded the document he carried in his deed. He thought about how that armor worked, how it had worked for years, how it had worked on Gerald Hutchins and the Marigold woman and the family with the basketball hoop. It worked because most people, when an organization with 400 members and a lawyer on retainer tells them they're wrong, decide that fighting back costs more than it's worth. The armor didn't work on James because James had spent 22 years in military logistics, learning that the document in your hand is the only thing that matters when everything else is noise. Chain of command, verbal orders, institutional tradition, none of it supersedes the written record. He'd learned that in supply depots and forward operating bases, and the kind of bureaucratic firefights that don't make headlines but determine whether equipment reaches the people who need it. He'd learned it so thoroughly it had become reflex. The deed was the document. Everything else was noise. So what happens Monday? He asked. Yeah, Monday, Maria said. We file the damages calculation, property value loss, legal fees, the cost of the fencing, the survey work, and we file the amended complaint adding the defamation claim, the eyesore statement from the board minutes. How do you think they'll respond? She paused. He could hear her smiling through the phone. I think, bien, she said. Sure that they're going to want to settle. James looked out at the fence line. His fence, his land, his deed framed on the wall behind him in UV protective glass. 16 years old and as clean and unambiguous as the day it was signed. Let them want, he said. The courtroom was not dramatic. That was the first thing James noticed when Judge Patricia Holloway entered and took her seat. No gallery packed with spectators. No television cameras. No moment of theatrical silence before the gavel fell. Just a Tuesday morning in a county courthouse that smelled like old carpet and printer toner, with fluorescent lights humming overhead, and a bailiff who looked like he was thinking about lunch. The machinery of justice, it turned out, was profoundly ordinary, which made it, somehow, more powerful. Maria Santos had told him this would happen. She had told him the moment of vindication rarely looks like the movies. It looks like paperwork, she had said. It looks like a judge reading quietly for 4 minutes while everyone waits. It looks like bureaucracy correcting itself. She'd been right about everything else. James had learned to trust her about this. Diane Foster sat at the defendant's table in a charcoal blazer, her posture still immaculate, still performing the role of the executive who controls the room. But the room no longer belonged to her. It had stopped belonging to her 6 weeks ago, when the discovery emails had entered the record and the HOA's attorney had stopped making eye contact during depositions. Karen Ellis was not present. Her attorney had filed a separate motion to be dismissed from the proceedings 3 weeks prior. The judge had denied it. Karen was represented today by the same HOA counsel, a man named Gerald Pitts, who had spent the last 2 months watching his confident motion to dismiss strategy dissolve document by document. Judge Holloway set down the summary judgment brief and looked at the room over the top of her reading glasses. "I've reviewed the submissions from both parties," she said. "I've reviewed the survey records, the deed history, the HOA's governing documents, and the discovery materials. I want to be clear about what this case is and what it is not." She paused, not for effect, but because she was precise, and she wanted precision. This is not a complex property dispute. This is not a boundary ambiguity case. This is not a prescriptive easement question requiring extensive litigation. The defendant's claim of prescriptive easement fails on its face because the use of the plaintiff's land was never open, notorious, and hostile under a claim of right. It was, by the defendant's own internal communications, a calculated decision made with knowledge that the land was privately owned. She let that sit for exactly 1 second. The deed is unambiguous. The survey is unambiguous. The plaintiff has held clear title to the 47-acre parcel in question since 2008, and the Meadowbrook Estates Homeowners Association has no recorded easement, no legal claim, and no governing authority over any portion of that parcel. Their own bylaws, Section 4.2, confirm this explicitly. She removed her glasses. The motion for summary judgment is granted. Gerald Pitts wrote something on his legal pad. James watched him write it and understood that the writing was the only thing left to do, the only motion that remained, the only performance of competence available to a man whose client had handed him a losing case and asked him to win it with confidence. Maria touched James's arm once, lightly, and said nothing. The judge continued. She awarded compensatory damages for the property value reduction, the $40,000 notation that had appeared in the county assessor's records following the HOA's fraudulent zoning complaint. She awarded attorney's fees under the state's property rights protection statute, BICE, which allowed fee shifting when a party pursued legally baseless claims against a landowner's clear title. She issued a permanent injunction prohibiting Meadowbrook Estates HOA, its officers, board members, and residents from using, accessing, or parking on any portion of James Rivera's property. Violation of the injunction would constitute contempt of court. She did not raise her voice once. When she stood and left the bench, the bailiff said, "All rise," and the fluorescent lights kept humming, and somewhere in the building a door opened and closed, and the ordinary Tuesday continued exactly as it had before, indifferent to what had just happened inside this room. James sat for a moment after the room began to move around him. He was not crying. He had expected, perhaps, to feel something large and sudden, the release of 3 years of documentation, of certified letters and county complaints, and insurance calls, and the $40,000 that had evaporated from his life, because a woman had looked at his land and decided her organization's convenience outweighed his ownership. He had expected a wave. What he felt instead was something quieter, something that had been clenched in his chest for a very long time, simply unclenching. He had been a logistics officer for 22 years. He had understood, from the first week of his military career, that the difference between a successful operation and a catastrophic one was almost never courage. It was almost never inspiration. It was documentation. It was the chain of custody. It was the record that said, this happened on this date, in this place. And here is the proof. He had carried that understanding off the base and onto 47 acres of farmland and into every photograph he had taken, every license plate he had written down, every dated entry in the notebook he had started keeping the first time he found tire tracks in his southern field. The deed had always won. He had known it would win. The work had been making sure the deed could be heard. Outside the courthouse in the parking lot, Maria opened her briefcase and pulled out a copy of the judgment and handed it to him. He read it standing in the October light. The paper slightly warm from the printer, his name on it, the property description on it, the words clear title, and Warsaw permanent injunctions, and Warsaw judgment for plaintiff, arranged in the flat, affectless language of legal documents that nonetheless meant everything. What happens to them now? He asked. The HOA pays the judgment. Pitts files a notice of appeal that goes nowhere because there's nothing to appeal. The record is airtight. Diane Foster either survives the next board election or she doesn't. Karen Ellis has a contempt order waiting for her if she comes within 100 yards of your fence line. Maria closed her briefcase. And you go home. He drove back on the county road that ran along his southern border. He slowed when he reached the field. The fence posts he had installed in April stood clean and straight in the afternoon light, the wire catching the sun in small, bright points. The private property signs were still there. The new ones, the ones with the case number printed in small text at the bottom, the ones nobody had touched since the injunction filing. That the land ran back from the road in long, quiet rows, the cover crop coming in green and low, the barn visible at the far end, the whole 47 acres exactly as it had been when he bought it, exactly as it would be when he was gone. He had not buried the lead. He had not needed to. The deed had been the argument from the beginning. Every document, every photograph, every deposition, every email Karen Ellis had written and believed would never be read, all of it had only been the architecture around the one fact that had never changed. His name was on the deed, the land was his, and no organization's institutional certainty, no matter how long it had gone unchallenged, could survive contact with that truth. He pulled back onto the road and drove home.